Well, hello, everybody. Thank you for joining me today. My name is Lynn St. I'm with ELG Estate Planning. I am an elder law and estate planning attorney, and I am also author of this book, How to Protect Your Assets from Devastating Nursing Home Costs. So, along with co-author Gabriel Heiser. So I'm so glad that you're joining me today. So feel free to ask your questions. As much as possible, we can make this interactive. And if you put your questions in the chat or put the questions on the Facebook Live page, they'll be relayed to me and I can answer them for you. So, to get started, that's usually the biggest question people have is they don't even know where to start. They don't know where to start with estate planning questions. They don't know what they should be asking. Everybody does a lot of their own research nowadays. You can look on the internet and there's a lot of information there, but is it accurate? Does it apply to you? So what my goal is today is to provide to you clear information that is not legalese and it's not confusing, and just to do my best to convey as much information as I can for you today. So if you live in Washington or North Idaho, and if you have any questions about estate planning, what it means, anything along those lines, long-term care costs, how to pay for long-term care costs, you are in the right place. So welcome, and I'm glad you could join me. So what we're going to be talking about today are some basics of estate planning questions, like what's an estate plan? Why do you need one? What's a will? Does a will cover everything? And then we're also going to be talking about a little bit more complicated, which is Medicaid and Medicaid long-term care benefits and how they might apply in a particular situation. So let's go ahead and get started. So one of the first questions that is usually asked and was asked today is, what is an estate plan? So basically, an estate plan is a plan for what happens upon your death or during your lifetime if you should lose capacity, which means if you're not able to manage your own personal affairs. So an estate plan can be a good plan, one that you put into place, one that accomplishes your goals, one you understand, or an estate plan could be kind of a mediocre or not so good plan. Maybe you don't understand it, maybe it doesn't fit your particular situation, or you could have what is called no plan. And if you have no estate plan in place, you might be surprised to learn that you actually do have a plan. It is the default plan. It is the state's plan for you. So that surprises a lot of people. They think, well, I don't have any estate plan. I haven't done anything. Well, maybe you haven't, but guess what? If something happens to you, the state does have a plan in place. And it's probably not the best plan, and it's probably not the one that you want. So you can choose. You can, most of the folks that I meet with, the reason that they come to us is that they want to understand their plan. They want it to fit their situation. They want to have confidence in their plan. They are just basically taking the bull by the horns. They are doing what they need to do, even though nobody likes to think about planning. Nobody likes to think about incapacity or death. It's human nature to put it off, but at some point in time, and at some point in time, people say, you know what, I'm kind of uncomfortable that I don't understand what my plan is, or I don't think it fits, and they just want to come and get some reassurance and get the right plan in place. So usually the people that meet with an attorney, such as myself, are the people that know that they want to take some action to choose to do a good plan. A lot of people take no action, and as a result, they have what I call the state's default plan. So you can choose. It's really up to you what steps to take. So I'm going to go cover what the state's plan is for you and why you might not want that plan. So question number 2, the next question, why should you have an estate plan of your own choosing? Why put a plan into place? Well, if you want to make sure that you are in control, that your estate goes to whomever you want it to go when you pass, or that you have appointed somebody to act on your behalf in case you can't, in case there's incapacity, that's why you would want to have your own plan. If you want to be in charge of your life, your business, your affairs, where your estate goes, basically, if you want to do everything that you can to control what can be controlled in this uncertain world, then you will have an estate plan, one that works for you, one that you understand. So we know a lot of people don't do estate planning. We know a lot of people who do estate planning. Oftentimes what people say to me is, I want to do this because I want to make it as easy as possible for my loved ones when I'm gone. I do not want to leave a mess for them. So they're thinking about their loved ones. They're thinking about how to make things easier for the time comes when, you know, they have passed on and their family is left without them. So either they're going to leave a situation which is pretty easy to handle, or they're going to leave a mess, because the state's plan typically results in it's a mess and it's expensive and it often involves court fights, on and on and on. It's just not a good situation. So that is the default plan, which is the state's plan. So if you don't want to leave a mess, or if you don't want to leave uncertainty, then take some action and don't have your estate plan be the state's default plan. Now, don't get me wrong. I'm not saying that the state is in any way malevolent or mean or doing anything that doesn't make sense. I mean, the state's default plan is what the state thinks you probably would want. So, for example, let me get into a couple examples. So let's say that you have no estate planning done and something happens to you. You are in a car accident and you suffer a traumatic brain injury, or perhaps, you know, it's been years and years and, you know, you've lost capacity. You have some form of dementia, Alzheimer's, for example, and you haven't done anything. You haven't put anything in place. Well, the state does have a plan, because if somebody loses the ability to manage their own affairs and they're still alive, there has to be somebody with legal authority to take care of things. I mean, it's just simply required. The state then will say, this person has lost capacity. What's the plan? The plan is the person who's lost capacity becomes a ward of the state. What that means is that they are declared to have virtually no rights, and a guardian is appointed on their behalf. So a guardian is somebody who is appointed by the court to make decisions for the person who's lost capacity. The guardian has to report everything to the court. Financials, personal plan, everything is reported to the court because everything is managed by the court. And what that means is all of the expenses of all this court management and involvement of the guardian, all of those things are paid for by the funds of the person who's incapacitated. If you're that person, it's all paid for by your funds, and you have no control over your finances or your personal health, and you haven't appointed who you want to be in control if you would have thought of it before you lost capacity. So the state has to be involved. The state guides all of that person's affairs. So that's the state's plan if somebody loses capacity. So what's the state's plan, the default plan, if you die without any estate planning that you've prepared? So the state's plan when you die depends on what your situation is. You might say, well, what do I care? I'm gone. Well, if you care about your family and if you care to make things easier for your loved ones, it does make a difference that you put a plan into place. So the state's plan, let me give you an example of what that would look like. Let's say you are a single person and you have 3 kids and you have no estate planning in place. Well, the state's plan for you, it's called the Laws of Intestacy, is that on your death, your estate will be divided 3 ways, equally among your 3 children. And when I said the state isn't mean in their plans, the state is trying to carry out what they think most people would have wanted, which is the 3 kids. You have 3 kids, they're all going to inherit equally, because that's what the state thinks most people would want. And that may be true. However, oftentimes people don't want that equal distribution. Say, for example, that this person is very close to the 2 kids and that 3rd kid has been out of their life for many, many years. They would disinherit them. They don't want them, they haven't seen them, they want them to have nothing to do with inheriting. But if they don't put a will in place that says, I have 3 kids and I want everything to go to these 2 and none to this child, then the result will be that this child who really the person didn't want to inherit will actually inherit 1/3. So the way to make sure your wishes are carried out is by putting them in writing in a will, because if you don't do that, then it will be the default plan for the state that the state puts in place for you. So one of the things that a lot of people ask is, well, you know, don't I have, or kids come in and they say, well, I'm entitled to inherit. You know what? No one is entitled to inherit from you. There is no one that has a right to inherit unless, number 1, they're your spouse, or number 2, they're your minor child. And there's specific rules that apply in that situation. But you can imagine a situation where maybe this single person has 3 kids and they want maybe just one of them to inherit. The other 2 don't have a right. Or maybe they want everything to go to charity. They, you know, love this particular charity. Then they've got to put it in writing to go to that charity. Otherwise, the state's default plan is for the 3 kids to inherit equally. So really, it's up to you. You know, think about what your goals are, what you want to see happen, and then what's the best way to have them happen. Because if you take no action, well, the state does have a plan for you, because the state knows death is inevitable, and so the state has a plan for where your assets go. So it's really up to you to, you know, take that action to put into place what is right for you. So the next question is, well, do I need a will? You know what? The answer for virtually everyone who is an adult is yes, you need a will. I don't care if your estate is mega millions or very small, you need a will. That is, unless you want the state's default plan. And you can bet the people with lots of money, they have very complicated estate planning to avoid estate taxes. You know, there's a lot of reasons why people who have a lot of money will have very good estate planning, because they know that if they go to the right person, they'll figure out how to avoid estate taxes, etc. But really what I'm talking to is more of what I call, you know, the ordinary person, people that don't have, you know, millions and millions and millions of dollars, and the person that maybe they have, you know, their bank account, their house, maybe their retirement account, maybe they don't have a whole lot of money, but they still need a will, because a will is where you say where things are going to go, and it makes it so much easier for your loved ones when you're gone. And especially important to have a will is people who have minor children, because it is through the will that you would say, you know what, if my spouse and I are both gone, I want my, you know, sister to be the guardian of my minor children. Because if you don't say that and you don't put that in your will, then when you're both gone, it may be your spouse's sister or brother that comes in and goes, no, I want the kids. And then there's this fight and the struggle, and it's very detrimental for the kids. It's very costly. It's bad for the family, and it's not what you would have wanted. But since you didn't put it in your will, you set it up for that kind of controversy. So having a will is really important if you have minor children. A will is also the best way to create trusts for someone. Now, a will takes no effect until you die. So if I have a will, if I have trust in it, none of those trusts take effect until I die. But when that happens, let's say I had a special needs child, I would create a trust for my special needs child so that their money is managed. They can stay on all the government benefits that they are receiving. That's one example of a trust. You can also set up a trust in your will. Maybe you have, lifestyle issues with, maybe you have adult children, but they can't manage their money, drug or alcohol issues, in-law issues, creditor issues. There's so many reasons that you might want to protect who is inheriting you. So you put a trust in your will to do that. And one of the most important trusts that you put in your will is if you are married and if you have any concern about long-term care expenses in your future, in your spouse's future, you're able to put in your will an asset protection trust that upon your death, your estate funds that trust, and any assets in that trust are not counted by the state as being your spouse's. And what that means is that after your death, let's say your spouse ultimately goes into a long-term care setting, they don't have to spend down to Medicaid's $2,000 level. They can have that $2,000 that the state allows for a single person, and whatever you put in that trust, be it 100,000, 500,000, $1 million, there's not a limit on it. So wills with trusts are very, very vital estate planning tools. So, it goes from the very, very simple kind of will to the more complicated will, but regardless, your situation is going to be different than anybody else's situation. And it is very helpful to get some legal guidance as, well, what's the best type of will and type of trust that I might want to include in my will? So, that's one of the reasons to go see an estate planning lawyer. They can give you that guidance. Wills, the laws about wills are very particular, at least in the state of Washington. They have to be, there's very formal execution requirements about how they're signed, how they're witnessed, etc. We don't accept, handwritten wills in the state of Washington. So there's a lot of reasons why you would want to get some legal guidance about how to do your will. So yes, do you need a will? The answer is yes, you need a will. So we're coming up on the 5-year anniversary of Prince's death, and celebrities in our society, get a lot of attention. And they get a lot of attention when they do things or don't do things they should have done. And so I was just reading an article about that. All these celebrities and all these people who have money, and they never did any estate planning. So, I mean, it's really human nature to set it aside, not do it. But it's not necessarily the right thing to do. Prince's estate is still in probate litigation, and it's still the IRS is saying, hey, the estate's worth way more than what others thought it was worth. So, it's probably going to be in litigation for a long time. I know some of you may have followed that the Zappos, the shoe company, the CEO, former CEO, he recently died. And despite how much money he had, he didn't have an estate plan. He didn't have a will. You can bet that is going to be in court in litigation for many years to come. So, I mean, those are just kind of interest because those are celebrities. And I don't want to, what I want to make sure the message that I get across is that really everybody needs a will, no matter who you are. If you're over the age 18, you need a will. So let me answer some of the questions that I'm seeing here in the chat box, which is, first one is, my husband and I just moved to Washington from out of state, from Maryland. We have wills and powers of attorneys done in Maryland. do we need to have these same documents redone in Washington now? The answer to that is, I don't know. It is something that you want to go see an estate planning lawyer to take a look at. The answer probably is the powers of attorney should be updated. The reason for that is that powers of attorney are supposed to be honored in every state. So if you have a valid one in Maryland, Washington and the Washington banks should honor it. But in practicality, what happens is if you take your power of attorney into a bank here in Washington and they say, oh, it's from Maryland, our policy here at the bank is not to accept an out-of-state document. So you go get a new one. Now, that is, for example, the bank's policy. Is that what the law is in Washington? No, it's not. The law says that they have to accept it, but will the bank accept it? No, they won't. So how do you resolve that? Well, you either go get a Washington power of attorney done so you don't have that fight, or you go to court and try to compel the bank to accept it. Either way, it's not a good situation. So generally speaking, when you move from out of state into a new state, you will want to have your powers of attorney redone. Do you need your Maryland will redone? I can't answer that because I don't know what the Maryland will says. The wills are, as I said, take effect only upon death. So you're not trying to get a bank to accept it. Yes, a Washington court will accept a Maryland will because if it's valid out of state, it's valid in Washington. But does it provide all the safeguards and all the benefits that you would have if you have a Washington will? It's hard to say. I don't know that. So it's anytime, even when we've done, estate planning for clients here in Washington or Idaho, I tell them, if you're going to move out of state, if you're going to go to, a different state, you're moving there, definitely have an estate planning and elder law attorney review work we did, because it might not be appropriate for the laws of the new jurisdiction. Next question is, does the trust need to be funded when it's made? So if we're talking about a will that has a trust in it, remember, the will takes effect when the person dies. So any trust that's contained in a will be funded at the time of death. So not funded when the will is created, but funded upon death. There are a lot of other kinds of trusts. A will that has a trust is called a testamentary trust. Lots of people have different kinds of estate plans. For example, revocable living trusts. Those are trusts that you create during your lifetime. So you'll sign a will and you'll sign a revocable living trust at the same time. If you have a revocable living trust or any other lifetime trust, then typically, yes, they are funded when they're signed during that person's lifetime. So I hope that answers those questions. All right. Next question is, does a will make sure all my property is transferred at death? The answer is no, it does not. And this is where a lot of problems arise, especially if the person has done their own will or they went to some attorney that didn't take the time to look at the person's entire estate. I mean, all of their assets, all of their bank accounts, their whole situation. And an estate planning attorney, to do a good job, has to be really nosy. We've got to ask a lot of questions. We have to find out, what are your assets and where are they located? You just can't, sign a will and say, oh, well, that covers everything. The reason for that is a will does not cover everything. So just think of it this way. Think of a bank account that you might have. You might have somebody else on the bank account with you. You are joint owners, and you might be joint owners with right of survivorship. So the titling of that bank account, of that asset, says where that account goes when you die. So that account will not pass under your will. That account will go to the joint owner. That's one example. Another example is, think of your life insurance policies or your IRAs or your 401ks. Those do not pass under your will. Remember when you filled it out, there's a beneficiary designation form and it says, on my death, I want this asset to go, you might say to your spouse or to your kids or whatever. But you, by filling out the beneficiary designation, have said where that asset goes. So the will does not capture those assets and funnel them under the will's operation. Those assets go outside of the operation of the will. So it's because of that that people have to have a better understanding of how the will works and how these other assets work so that we can put them together so it provides the estate plan that the person wants. So let me give you a couple examples of why it's important for the person to understand these issues. So, and I always take from real world examples. So let's take that single person again, and then they have 3 kids. And in this situation, they want the 3 kids to inherit everything equally. And the will says that. I want everything to go to my 3 kids equally, all right? And then somebody thought it was a really good idea, and they told the person, you know what, just make things so much easier. Just put, your one of your kids, let's say it's the kid who is going to be the power of attorney for them, just put them on your bank account. Let's say that this person has a very simple estate. All they have is one bank account. It's worth $300,000, and they put the one child on that bank account with them as a joint owner. You might see what the problem is here. When the parent dies, who's the owner of that one account, that $300,000? Well, just the one child. Now what's going to happen? Well, that one child may say, I know what, mom or dad's wishes are. It's to divide this money up, and they will do that. Or the one child could say, you know what? Mom put me on this bank account because she liked me best, and it's all mine. So that happens. And so what happens after that is the other 2 are going to either live with it, and the whole family is pretty much broken apart, obviously, at that point, or the family is going to go lawyer up the other kids and are going to start litigation, and then it's going to go to court, and a lot of money is going to go out in legal fees. So that's a situation that happens not infrequently. How do you avoid that? You avoid by understanding what it means to put somebody on your account as a joint owner. You avoid that by getting help of an estate planning attorney who helps you walk through your estate plan so that you wouldn't ever even think of putting, one kid on your one big asset as a joint owner. I guess one of the reasons that people do an action like that is they say, well, I want to avoid probate. I don't want my will to have to be probated. There are so many ways to avoid an otherwise unnecessary probate. What would have been done in this situation that would have been correct would have been not to make the one kid a joint owner, but to make them perhaps an authorized signer on the account during the parent's lifetime. But on the parent's death, that bank account pays on death, just like a beneficiary designation, pays on death to the 3 children. So they each get 1/3, 1/3, 1/3. There's no room for argument. A correct pay on death direction on that bank account would have solved all of those problems. So a lot of times people want to do their estate planning on their own, and unfortunately what happens is they just don't know the nuances, the complexities. They take bad advice. Don't ever take legal advice from your neighbor necessarily unless they are a really good lawyer or from your friends. Don't ever take it from your bank teller. I mean, financial advisors and accountants, they have understanding, but they can't give legal advice. Only lawyers under the law can give you legal advice. So, you know, be careful where you get your information, because it might mislead you in the wrong direction. I want to give you one more example that is about retirement assets. So I have seen more than one case where the will says, oh, all my retirement assets go here or there. That doesn't work. Your will can't say that. So here is a case that happened in Washington. So husband and wife, they're married. I can't remember which one, but let's say the husband has a big 401k retirement account and they get divorced, and of course it gets divvied up. And so the husband thinks, okay, this is all taken care of. You know, my ex-wife's been taken care of. You know, she no longer has any rights to my 401k. But what the husband didn't realize, and nobody brought it to his attention, he simply didn't know, is that he had to make a change on his beneficiary designation on his 401k, but he didn't do that. So his 401k still said it pays to this person who is his ex-wife. You know he didn't want that. So you can envision the next step. The next thing that happened is he dies. And then the question comes up, well, who gets the 401k account? Well, the beneficiary designation on it says it goes to the ex-wife. The rest of his family says, no, it doesn't. She is his ex-wife. She doesn't get any of it. Well, this is called the Egelhoff case, and it went up to the U.S. Supreme Court. And the U.S. Supreme Court said 401ks are governed by federal law called ERISA. And under those laws, the Washington law, we had a very favorable Washington law that says, you know what, if you get divorced, we know you don't want your ex to get anything. But the U.S. Supreme Court says Washington law doesn't apply. So under the ERISA law, who got that retirement account was the ex-wife. So really, really not the result that he probably wanted, but that is the result. That is what can happen when people don't understand their assets, don't understand what laws apply. So that's one of the reasons that it really is important to get some good legal counsel to help with your estate planning. Because there's just lots of curveballs. There's just lots of things that can go wrong. Which leads me to the next question. And people often say this, and I totally get it, is why should I hire an estate planning lawyer? I mean, that is expensive. If you've ever hired a lawyer or gone through any kind of legal process, you know legal fees are not cheap, period. That's how it is. So understandably, many people will say, well, I can just do my own estate plan. And in this age of the internet, you can probably go online and you can probably find a form. You might even get legal counsel that you get from the person who sold you the form. The reason that I did this is that, you know, how good is that legal counsel going to be? The reason I say that is that if an attorney is in private practice, they will charge you for their services, and you would expect that. You expect to pay for professional services. Whenever you're looking at something where you're getting it on the cheap, you have to wonder, well, what am I not getting? What am I giving up? There is nothing like a one-on-one meeting with an attorney. You can do it in person, you can do it on Zoom, but you make sure that that attorney has your back and not somebody else's. They owe a responsibility to you to do the right estate plan for you. And when you buy it from some online company, I mean, are you really getting that advice? And you got to wonder. So yes, you could try to do your own estate plan yourself. I've already explained some situations and given you some examples of why that might be a bad idea. Of course, you know, I'm an estate planning and elder law attorney. I've seen things gone wrong. I've seen the benefit of the services that are provided by a good estate planning attorney. I do recommend that you seek them out. How are you going to find a good estate planning attorney? You know, do your research. You can talk to friends, relatives, see who they like. Make sure that the attorney is well qualified. Make sure that they're not what I call a generalist. A generalist is somebody who, you know, kind of think of it in doctor terms. You don't go to an orthopedic, you go to an orthopedic surgeon if you need a shoulder surgery. You don't go to a generalist, they won't do it. Is your situation important enough that you're going to go to somebody who really knows what they're doing? A generalist, somebody who will, you know, do family law, DUI, criminal law, charge you $500, give you a form, you sign it, nice to see you. They're not providing you that level of service that you're not better off than if you would have done your own online form, in other words. So, you know, it's up to you. I've already explained. You can have a really good plan that provides great results. You'll need to see a well-qualified estate planning attorney to do that. Or you can have a mediocre plan and it's kind of going to be a crapshoot. You can do that online. You can see somebody who doesn't really focus on estate planning. Or you can do the state's default plan, which we've talked about, which is your no plan, but there is still a state default plan. So, you know, it really is, you know, where you're at in your life, what's important to you. You know, do you see value in the services that are being provided? Do you trust that person to care enough about you to do a good estate plan for you? So I encourage you to look into it, to do your research, you know, to reach out. You can interview attorneys, see who you feel most comfortable with. I mean, there's all sorts of things. It's important, so that I do really recommend that you do that. So the next question that we're going to get into is really has to do with a very complex area of elder law. So what I've been talking about up to this point is something that an estate planning attorney should be able to do well for you. When it comes to the asset protection trusts, you may need an estate planning attorney with elder law experience. Elder law experience doesn't mean we just work with old folks. I wish there was a better name for elder law. What it means is we understand what government benefits rules are, how to protect people so that they can still qualify for government benefits. And even if they're needs-based benefits, which a lot of our government benefits are, Medicare, Social Security, disability, insurance, those are not needs-based benefits. But SSI, Medicaid, those are needs-based benefits. And people who are disabled or people who go into long-term care facilities, they will be looking at needs-based benefits. And for those people, they need to use an elder law attorney who has experience, a lot of experience in Medicaid, because it's a very, very complex area of law. So that's what we're talking about now is Medicaid. We're talking about how to get the state to pay for long-term care costs. What I want you to know is that there are numerous ways that, numerous plans that exist so that the person will qualify so that the state will pay for care. But it's not necessarily easy. It really depends on the person's circumstances. Look, if you're listening in and you've got millions of dollars, you're not concerned about Medicaid, at least not for yourself. You might be concerned about how to protect assets, your money for your disabled child, so keep listening. But if you're one of those people that, you know, you can't foresee any way that you're going to spend all of your money on your or your spouse's long-term care, you could have a 10-year event at a care facility and it'll go through 150 a year times 10, 1.5 million. It's okay. It's not going to really hurt you. Then you're not concerned about Medicaid. So you really don't need to listen any further. Or let's say you have long-term care insurance for life. You know, I don't know of anybody who sells those type of rich policies anymore. They used to. Most long-term care insurance policies have a term of limit of 2-3 years, maybe up to 5 years. So do keep listening, because with a long-term care event, it could exceed your long-term care benefits. And so you might be interested in knowing, well, what kind of planning does exist for Medicaid? Because there are really good plans for that situation. So what most people do, and this is what I really want to get the point across, is most people do no planning. Most people, when they're faced with a long-term care event, they don't know what to do. I mean, if you're facing long-term care, you're dealing with declining health, you're dealing with huge expenses, there's huge caregiver burdens. I mean, in my family, we had 14 years of long-term care. It is overwhelming. It is huge. One of the reasons that I formed Elder Law Group was because I learned so much, and I wanted to share that information because, having gone through it myself personally, I knew that there needed to be better resources out there. Most people, though, what they do is they just spend their money. They'll go to a lawyer. They'll go to, a lawyer says, oh, there's nothing you can do, just spend your money. They might even go to an estate planning lawyer that says, there's nothing you can do, just spend all your money until you're within the standards that Medicaid allows. That is bad advice, because there almost always is something that we can do to make the quality of life better for the person who needs care, for their family, to protect assets, and to help bring in resources so that it's not so stressful and overwhelming. This is coming from my heart because I have been through this. So this is what I want to share with you. This is one of the reasons that I wrote this book, because it's so important that people have this knowledge. It is just not generally out there. You can go on the internet and research Medicaid, and your mind's going to be blown. You're going to be overwhelmed by how much information is out there, and there's no way you can fit the puzzle together. So I want to help give you some information so that you can kind of see that there are things that can be done. So you don't have to become impoverished to get Medicaid benefits. Now, is that true if you're a single person? A single person, the standard for countable assets under Medicaid for a single person is $2,000 in countable assets. That's it. That is an impoverishment standard. It's been the same since January 1 of 1989. It has not changed. $2,000. In other words, the state says, if you're a single person, you got to become poor. That's the state's plan for you. Now, if you come to an elder law attorney, we have a lot better plans than that. There are many things we can do to protect assets, even if it involves gifting within the 5-year look-back period, because oftentimes that is an excellent way to preserve assets so the person doesn't lose everything that they've worked their whole life for. So single person, do have hope. There are things that we can do, a very good Medicaid asset preservation strategies to protect your money, get you good care, have the state pay for the care, and yet your money will go where you had wanted it to go. So, and there's a lot of exceptions to Medicaid's rules. The 5-year rule that you can't give away money doesn't apply to spouses, doesn't apply to a disabled child, doesn't apply to a caregiver child. There's so many exceptions that we can utilize to benefit the client. And one thing, kind of harkening back to what I said about wills with asset protection trusts, the very best way for spouses, for couples to make sure that when one is gone, the other never becomes poor, is to have a will with an asset protection trust in it. Because if you are a widow or a widower and your spouse set up a trust in their will for you, not only can you have that $2,000 in your bank account, You can have whatever was put in that trust, however many hundreds of thousands, tens of thousands, you can have that and the state doesn't count it. So that's one big exception to the impoverishment rule that Medicaid has for single people. So single people have hope. There are many things that we can do to make life better if you need long-term care and to protect your assets and get the state to pay for your care. Couples have it so much easier. Let's say you're not single, you are a couple, and one of you needs care. Well, the state's rules for a couple say that in terms of countable resources, you can have basically between $60,000 and $132,000 in the bank, countable assets. What's not countable? Your house is not countable. Your car is not countable. Your personal property is not countable. Your irrevocable prepaid burial plan is not countable. There are things which are not countable. But nonetheless, the state says for what is countable, if you're a couple, it's between $60,000 and $132,000. So I want to give you, and most people, if they have that much money, I mean, and you can see, if your spouse is going into $11,000, $12,000 a month care facility, that $300 is going to go real fast. So take action. What can you do? Let me give you an example. So let's take, I like the names Fred and Betty. Let's take Fred and Betty. And let's say that they own a home, they own a car, they own their personal possessions, and they have $300,000 in the bank. Well, $300,000 is more than the $60,000 to $132,000 that the state says you can have. Fred has been taking care of Betty. Betty has Alzheimer's, and Fred just can't do it anymore. Caregiving is overwhelming. It really takes a toll on the caregiver spouse. So Fred has reached the point where Betty is going to move into a nursing home. That nursing home can cost $10,000, $11,000, $12,000 per month. You can see that this couple will run out of money. But they had the foresight to do good estate planning. So I've got good durable powers of attorney I can use. So even though Betty has lost, she's got Alzheimer's, she can't make any action, take any action on her own behalf. She's authorized Fred under her durable power of attorney to take whatever action that he needs to work with us to do a Medicaid plan. And so we're able to do a Medicaid plan because we're able to help Betty through her good durable power of attorney that we have. What are we going to do? Well, what we're going to do is we are going to say Betty's moving into skilled nursing. Under those rules, she can keep 130. With Fred's 2,000, it's basically, 132,000. So I'm going to say 130,000 because it's easier math for me. They have 300,000. Fred gets to keep 130 of that. They have 170,000 too much money. Most people are going to spend it down, spend it down, spend it down. Most lawyers are going to say, spend it down, spend it down. An elder law attorney with Medicaid skills is not going to tell you that. What we're going to do is we're going to take that 170,000 of countable money and we're going to make it non-countable. How we do that is we take that 170,000, put it in Fred's name. Fred buys a Medicaid compliant annuity. This is the type of annuity that Medicaid allows him to have. And by buying this annuity, he has taken what is countable money and he's made it non-countable. So Betty qualifies for Medicaid without this couple having to spend down a dime. And it's done at the time of need. So you're saying, well, how does that work? How does that annuity work? So the math on it is, remember, the state allows it. The state allows this couple to have this annuity, this Medicaid annuity. So Fred takes his extra 170,000, he puts it into this annuity. It will pay him back month after month after month
over the next 60 months or 5 years. So the math on it is he will get, every month, he'll get back $2,833. That money that he gets back from the annuity, he took his $170,000, he put it in an annuity, he gets it back each month over the next 60 months or 5 years. He just puts that over into a savings account because that money never needs to go toward Betty's care costs. Fred's income doesn't go toward Betty's care costs. The other savings account, 130, does not pay towards her care costs. Nothing that Fred owns does. We put everything over in Fred's name. What pays for her care? Her income, and then the state pays the rest. What does the state get back from this couple at the end of the day? Nothing, because we take all the assets that were the couple's, put it only in the husband's name, only in Fred's name, and when Betty passes away, the state has no estate recovery because there's no assets in her name. Everything was in the husband's name, so he is able to keep all of his assets, yet we're able to utilize the Medicaid benefits to pay for her care. And at the end of the day, when Fred is gone, then their family will have what they work for. So that example is to just give you one fairly simple example of a Medicaid asset preservation strategy. What I want you to take away is that that might not be the right one for you or for your family, but there may be a very good strategy for you if you're interested. And a lot of people say, well, you know, I don't want to use Medicaid. It's like, you don't have to. But before you make the decision that you don't want to use Medicaid in your family, why not find out what your options are? And believe me, I have met with clients and we have said, here's a Medicaid strategy. And they've said, you know what, I don't want to do that. That's perfectly fine. But at least they aren't doing it out of ignorance. They're doing it out of place of knowledge. And what my goal is to share knowledge so that people then can take the best actions for themselves. So, couple of questions about, Medicaid. A lot of people have heard the spend down. And spend down is usually a part of a Medicaid strategy. So spend down could be pay off your debts, pay off your credit cards. It could be buy a bigger house. You might say, why am I doing that? Because sometimes that's a good Medicaid strategy. You can put up, a single person can have equity of over $600,000 in their house. There's estate recovery questions that come with that, but I don't want to, get tied up in those right now. You can buy a car. We had one case where there was just $40,000 too much. And that day was the end of the month. They bought the $40,000 car in the name of the Medicaid applicant. They got on Medicaid. The next day, the car got transferred to the brother, no penalty. So there's a whole lot that you can do. So that is an example of a single person, a simple Medicaid strategy for a single person. Is any money non-countable? No, money is countable. Other assets are non-countable. You can list an asset for sale. You have a vacation home. That's a countable asset unless you list it for sale, then it becomes non-countable. This is just a few examples of the exceptions to the rule, and you just have to know what those exceptions, you need to know what the rules are, and then you need to know how to apply them to your client's case to benefit him. All right, well, that pretty much wraps it up for me today. I want to thank you all for participating, for spending time, for sending questions. My name's Lynn St. and I'm the owner of ELG Estate Planning and Elder Law Group. You can reach out to us at 509-468-0551 or go visit us on the web. Our address is www.eldgwa.com or elderlawgroupwa.com. Again, if you have any questions, feel free to reach out. We're happy to answer them. And I wish you all well in this new year, and everyone stay safe. Thanks so much for joining me.